Ready? Start. The SAC, a non-banking financial company, holds 50% of the paid-up capital in RPG Raychem Limited, full stop, upon the relaxation of rules for foreign entities conducting business in India, Tyco, USA, licensed the right to manufacture and sell the relevant industrial products in India to its subsidies. Stop. This subsidies sought the assistance of the SAC in this case to ensure that RPG Raychem Limited did not continue rival business in the same industrial products in India. Stop. Accordingly, an agreement was entered into by the relevant subsidies of Tyco, USA, under which the SAC was to vote in a particular manner at a general meeting of RPG Raychem Limited, such that Tyco's specialized business was no longer carried on in India by RPG Raychem Limited. Stop. In consideration for voting in the manner agreed, Tyco, Dubai paid certain sums to the SAC, and the treatment of such sums fail for consideration before the assessing officer and subsequently, before the Commissioner Appeals. Stop. The appellate, tribunal held that since the income was one-off in nature and arose in the context of the appellant, though through a company in which the appellant had substantial control, relinquishing a right, it ought to be treated as capital receipt and not a revenue receipt. Point for consideration is whether payment received by the SAC for exercising its voting right in a company in a particular manner would be a capital receipt or revenue receipt. Stop. Held, though the Commissioner Appeals did not accept the SAC's contention that this was a one-off payment, it could not be said that the SAC was in the business of voting in a particular manner at shareholders' meeting for this to be treated as income from other sources. Stop. The tribunal noticed the Bombay High Court judgment in the Old Spice case and found it to be applicable in the facts and circumstances of the SAC's matter. Stop. Further, the income obtained by the SAC from exercising its voting rights in a particular manner was a consequence of the investment of the SAC in RPG Raychem Limited. Stop. Even by such logic, the income could have been regarded as a capital receipt. Stop. The appellate tribunal's treatment of the matter, particularly, in the light of the judgment of the Bombay High Court, does not call for any reconsideration. Stop. The tribunal appropriately held that since the income was one-off in nature and arose in the context of the appellant, through a company in which the appellant had substantial control, relinquishing a right, it ought to be treated as a capital receipt and not a revenue receipt. Stop. Appeal is disposed of by answering the question in favor of the SAC respondent, The judgment of the court was as follows, The legal question raised by the revenue in this appeal is as to whether the payment received by the SAC for exercising its voting rights in a company in a particular manner would be a capital receipt or a revenue receipt. The Commissioner Appeals disagreed with the submissions of the SAC that the income had to be treated as a capital receipt since it was one-time in nature and not a recurring source of income. Stop. The appellate tribunal relied on a judgment of the Bombay High Court to hold that the Commissioner Appeals had erred and the income had to be treated as a capital receipt. In the Bombay case, the matter pertained to the relinquishment by the SAC of the right to use brand Old Spice. The original owner of Old Spice, Sultan, UK, had an agreement under which the brand was promoted in India by the SAC. Stop.